stakeholders under the auspices of the Rivers Restoration Movement has accused the camp of the state governor, Siminalayi Fubara, of twisting the recent Supreme Court's judgment to avoid implementing it. RRM, in a statement signed on Thursday by its Director General, Johnson Judgeville, and its secretary, Mrs. Sarima Abata, described what it called the deliberate misinterpretation of the judgment as vexatious, misleading, and infuriating. The stakeholders congratulated Speaker Martins Amehule and 26 others on their victory and maintained that the Supreme Court's ruling had given life to the judgment delivered by Justice Omotosho at the Federal High Court and that of the Appeal Court. RRM said it was shameful and dishonorable that the custodian of the law in the state was encouraging his appointees to disobey orders of court through misinterpreting valid court judgments. The group said it was also worried that even with clear statements by the Court of Appeal, the governor's team still went ahead to appoint members of the River State House of Assembly Service Commission that had been screened by the Okojombo-led team. But the River State government insisted that Monday's Supreme Court judgments did not reinstate Martins Amehule as the Speaker of the River State House of Assembly. Reflecting on the Apex Court judgment, Dagogo Israel Iboroma SAN, the Attorney General and Commissioner for Justice in River State, said he attended the court proceedings and lamented that the real judgment had been misinterpreted in various platforms. Honorable Don, what do you make of this story? You're a legal practitioner, so more legal insights into the implication of the Supreme Court dismissing the appeal of the governor.
Well, good thing that today is a day of love, and we would try as much as possible to, dissect this issue. Very, very lovely, very lovely. The thing is that the appeal, ABJ 1071 2024, was an appeal that was lodged by the governor of Rivers State against members of the House of Assembly. Actually, the matter started at Federal High Court in Abuja, ABJ FHC 133, 2023, sometimes in December of 2023. And the judgment of the court, Justice Omotosho's judgment, was so sacrosanct, very explicit. In fact, it had a lot of reliefs that was sought. In fact, let us make it clear to Nigerians. The attitude of the governor, the Simplify movement, whatever it's called, going forward and going backward when it has to do with court proceedings, is something that's so worrisome. Because if you remember, even at the Federal High Court, if you look at the judgment, the judge also told Nigerians that they did not challenge that proceeding. I hope you understand.
They withdrew
all their counters. They did not challenge the proceeding, leaving the processes or the originating processes of the Martins Amehule and 27 standing before the court. And after several notices, hearing notices and all that as is required by the rules of court, they still decided not to join issues or further join issues with the originating processes. The court couldn't wait forever. Maybe because they have looked at the processes or the defense they intend to strike.
They said they withdrew that counter affidavit as a result of the peace pact.
There was no affidavit compelling them or showing that the president's peace pact was a condition for them to withdraw. The court did not also order them to withdraw.
Okay, now what you're saying, if I understand what you're saying, is that the withdrawal of that matter from court, the withdrawal of the counter affidavit
was discretionary.
Was not premised on the peace pact.
At
They did not when they were tendering their reasons for withdrawal, they did not tender peace pact as a reason.
Of course.
So the court is unaware of that arrangement.
Of course.
Okay, go ahead.
Because it's not, in fact, the court is not supposed to be involved or concerned with whatever happens outside the court. The court is also only concerned with issues, facts, and evidence brought before it, and by duty to analyze what is before them. The court is blind as to whether they went for a peace pact or not.
Okay.
Now, as at the time they withdrew this counter affidavit, issues have been joined by the parties. Issues have been joined. And they were also reminded of the issues after several notice for them to come and defend their matter. But they chose to withdraw. And when judgment was finally given in that matter, you remember now they appealed. And the question was, what are you appealing? Facts presented, evidence that was before the court not challenged. In law, once there is a judgment or once there is evidence or a fact stated by a party and it is not challenged, including evidence, what the law says is that the party that is supposed to challenge that fact or contradict or counter contend on that fact would have been seen to have abandoned the facts, and waive his right to challenge it, and in consequence admitted the facts already before the court. So when they failed to challenge the judgment, or when they failed to challenge the originating processes and withdrew their processes, what it means was that they agreed in toto with the originating processes that Martins and Mewule and Co. filed before the court. That is the implication. And you remember
of withdrawing
at the Federal High Court where issues have been joined.
Now, to a large extent, this exercise was also repeated in the Supreme Court.
Now, they went to Court of Appeal.
Okay, go ahead.
In CSAB, ABJ, I can't particularly remember the number now, but they went to challenge that judgment. They filed a stay of execution that was dismissed, and then that matter was also dismissed against them, against the government of Rivers State, and then they further filed an appeal, lodged an appeal at the Supreme Court.
When you say matter was further dismissed at the appeal court, I want to understand.
What it means is that the court upheld the judgment of Justice
so
J.K. Omotosho.
That matter.
Because that was why they appealed.
All right, go ahead.
And they filed a motion for stay of execution, which was also dismissed. And then they further, because it was their right to appeal, they further appealed to the Supreme Court. Now, on a day where I would have expected that they would have allowed the processes they have filed to be determined by the court, one way or the other, in their own thinking, they decided to withdraw. Maybe they have looked at it. Their defense may not have been strong. They may have considered other issues that would have been against them. That would have been against them. One of the issues
that was laid.
I'm coming to what the issues.
The reasons they gave.
That they said because the
it has been overtaken by events.
The action, premised on that judgment was overtaken by events. The question is, what event are we talking about? Event of presentation of budget? The question is, the matter that went before Justice J.K. Omotosho, did he only touch on the issue of budget? That is not correct. There were other reliefs that were sought in that judgment. Okay. Such like, if you look at the order 2 of the judgment, the orders of the court, order 2, you will see where the court made clear mention, say, an order restraining. I think it's an order restraining the governor, okay, which is the 11th defendant, from presenting, requesting, or nominating. it could have also included the issue of presentation of names for confirmation for commissionership, or all those appointments that was done within the period. Those are part of what the judgment also covered. So if the Attorney General was saying that it was on budgetary issues, I beg to disagree. Order 2 of that judgment did not just make provision for a budget. It also talked about other things that the governor could have done within the purview of his power, such like presentation of names to the House, nomination of candidates,
basically governing with this 3-man assembly or 4-man assembly.
No, the court restrained. Look at the language of the judge.
Yes, go ahead.
The order was to restrain the governor from presenting, nominating, or confirming anything that it was within the governor's power to do to the so-called Okojombo's assembly. The court restrained him, except it will be done before Right Honorable Martin Chike Amewule's assembly. So, in other words, what the court was saying is that the court has stopped the governor from dealing
with the
Okojombo. So, what Justice Jacob Motosho expected the governor of Rivers State to do was to begin immediately to recognize the legitimate House of Assembly members led by Chike Martins Amewule. That's what the court judgment or the second order of the judgment of the court portrayed. So when people begin to grandstand by saying that the judgment had to do strictly with the budget presentation and that 2024 has elapsed, the question is, was there a legitimate or a legal event that was overtaken by time? Who determines what is legitimate or legal? Is it in the eyes of the appellants or the court, which will have brought issues before them to look at? So it was an erroneous action by the appellants or the governor of Rivers State to have withdrew that appeal, citing the issue of being overtaken by event. In fact, in any case, that was a matter that was in contention. I don't know whether you understand. That budget was in contention. So when you withdraw against a judgment that you did not challenge, the implication is that you have accepted that the judgment of J.K. Motosho stands and is operational, and that is what it is. And thank God, by virtue of the dismissal order of the Supreme Court, it goes to show that the judgment that is before Nigerians and the judgment that we are talking about today is the one that favors Right Honorable Martin Chike Amewule. And there's no other. So, as we speak to you today, if the governor continues in the face of this withdrawal to deal with the Okojombo, then the governor is calling for impunity.
Now, if I may understand what you have said so far, you know, for the benefit of clarity and for the benefit of our viewers. Now, you are saying, Honorable Don, that in the first instance, that the judgment that the governor appealed, the judgment of Justice Omotosho, that the governor appealed, is not only limited to the 2024 budget. Okay. There were also other judgments, you know, that made up other issues that were handled by Justice Omotosho that was addressed in that judgment.
Yes, because if you even look at the judgment, you see how the judge, I respect Justice Omotosho. It's a judge that have appeared before. I'm sure he's a thorough man. He's a man that does his job well. You know, I know, just regards to all other judges in Nigeria, they are trying, not really easy. But I know Justice Omotosho. Now, if you look at the same order, you will also see where he restrained, he ordered the Commissioner of the Inspector General of Police to, you know, he should give them protection. You know, there are other incidents, reliefs that was sought in that originating process, okay, that the court confirmed. So why will anybody, for Christ's sake,
Now,
as lawyers, we must learn and continue to uphold the integrity of the legal profession and the rule of law. It's not political now.
That still brings me back to what I was saying earlier, that I said for the benefit of clarity, which you have further clarified, that the judgment was not limited to.
It wasn't limited to the
2024 budget. There were other reliefs that were sought.
Exactly.
And that the implication of the withdrawal of this matter at the Supreme Court is that the judgment of Justice Omotosho is binding
on
and
the
operative
governor currently.
And now, while the governor and the governor's legal team is interpreting only one relief that was sought, which was the 2024 budget, you're saying that there were other reliefs that were sought in that judgment, and these reliefs are binding on the governor. Is that what you're saying in essence?
The court is so clear. I mean, in Registrar Trustees of Ifeloju Friendly Union, okay, it is, in fact, it's a recurring decimal now, that once an appeal, okay, once an appeal is, if you withdraw an appeal, apply to withdraw an appeal where issues have been joined, the circumstances alone goes to tell you that the party whom have withdrawn the appeal have accepted the position of the respondent. Now, I'll break it down a bit. When you file a matter as a plaintiff or as a plaintiff now, and then you haven't served the other party, or you have served the other party, but the other party have not responded to that processes. Now, at that stage, the law gives you the discretion to withdraw your matter without leave. You don't need to seek leave to withdraw your matter at that stage. And only against a Leoju. It's a locus classicus of that matter, 1981. One Nigerian Weekly Law Report. If you withdraw at that stage, you don't need to seek leave of court to withdraw, because it is taken that you have not put the other person to work. I hope you understand. A court is a court of justice. And any time that cost is awarded because of the event. So once there is a withdrawal at the stage where matters have not been joined, then it means ordinarily the court can struck it out. You can refile. You can come back. I hope you understand. You may decide to withdraw because maybe part of your evidence are not straight, or you needed some other person as a party which has not been joined to the suit. So you can withdraw without any kind of leave. But it is not where matters have been joined, parties have exchanged processes, pleadings have been settled, and on a day of adoption of the judgment, of the appeal, you tell the court that you want to withdraw. What does that tell you? Ordinarily, does it not amount to accepting what is before the court? And that is a position. Because what you are withdrawing against is a judgment that is operational. We must understand the facts. Judgment that is operational against you. That is what you are withdrawing against from. So when you withdraw from it, you are saying, I don't have a defense enough to counter or contend against this judgment. Therefore, I want to withdraw. So the reason for withdrawing is immaterial. I don't know whether you understand. The reason for the legal implication of withdrawing an appeal that is ready for adoption after parties have exchanged briefs, settled all their pleadings, is what we should look at.
All right.
It is not the reason for withdrawing. If we look at the reasons alone for withdrawing, when we are grandstanding, and that is not true, and that cannot be correct. So I beg to differ with Honorable Attorney General that says that the judgment of the matter filed on the 15th of December had to do alone with the budget. I beg to disagree. And when they said that it didn't have to make mention of those that defected, nobody says that the orders was made. But when the court gives an order and says, except to present this budget to Laurentia, what has the court invariably said? Is it not by recognizing Laurentia as the person that should take the budget? So why are we grandstanding? Why are we grandstanding? Why are we grandstanding? We have got series of matters have been filed. We've been part of this. Have been filed, and on all occasions, on the courts that has the jurisdictional powers to handle these issues have all given judgment in favor of Martin Samiewule and the 27 lawmakers. So why is it too difficult for the governor?
Now, there was another issue. There was another issue that was raised, with regards to this Supreme Court judgment. When they were speaking, and these have been the arguments from different quarters, that the judgment of Justice Omotosho was pre-defection. It was pre-defection. Now, that suit was filed around, I think, November, and the lawmakers defected December. Allegedly defected December, pending when court says that. So now, when you look at all that, they are now saying that as at the time, judgment was given, that the lawmakers had not defected. Now, which brings me to another point. That judgment was given January 20th, 2024. But that particular judgment was filed in November. The lawmakers allegedly defected in December. Right? Now, the question I want to ask is,
I don't agree that they defected, but the alleged
I said allegedly defected, pending when the court upholds that defection. So for now, it is allegedly. So now, that matter started in November. The lawmakers allegedly defected December, and judgment was given 20th of January 2024. Now, the question I want to ask, when the issue of post-defection and pre-defection comes into this matter, because you recall that there is another matter, questioning the legality or validity of the speakership of Martin Samiewule, and also the pleading the court to vacate the seats of the 27 lawmakers before a federal high court sitting in Port Harcourt. I think that matter should come up 17th of this February, I think. But now, when we look at all that, now the thing is, they are saying that this matter that is coming up 17th of February is post-defection. The judgment of Justice Omotosho is pre-defection. Can you make it make sense to me and our viewers as well? What do you have to say to that?
Well, just to be much accurate, because I know that the so-called alleged defection took place in December. And because Martin Samiewule and the other 26 lawmakers were the ones that initiated the Federal High Court processes.
In November?
Yeah. Obviously, they didn't go to court to ask the court to determine whether they had defected. They went to court reporting to the court the experiences they have been getting in terms of the frosty relationship between them and the governor or government of Rivers State. And they also sought the court to make an order protecting them as members of the Rivers State Task Force. Now, upon this suit, and unknowingly and erroneously to the governor of Rivers State and the government of Rivers State, through the Honorable Attorney General, they filed a suit seeking to declare the seats of the members of this house vacant.
Who filed the suit?
It was the government of Rivers State.
The government of Rivers State?
Yes.
Filed the suit
yes.
seeking to declare the seats vacant?
Exactly.
That is after the alleged defection?
Yes.
All right.
Now, we are not arguing. I mean, it will be preposterous and unreasonable to argue whether the matter was pre-defection or not. Of course, the dates are there to confirm. What we are talking about the judgment we are referring to is the fact that the judgment did not only touch on the issues of the budget. That is settled. You can look at the judgment. That is settled. On the issue of pre or post defection, with all respect, even if the matter is sub judice, I do not find, or I do not believe that there is any defection. Because now, for there to be defection, I've said this obviously severally on this show. Defection, membership is determined by registered members. You can't be a member of an association without registration. You cannot be a member of an association without registration. And that throughout the proceedings, initiated by the governor or the Okojumbo and co, there have not been any affidavit that has carried any evidence to show that indeed.
Now, what was the affidavit that,
Can I finish?
That was said to be presented before the House?
I mean, there are no. What do you mean by affidavit? What do you mean by affidavit that was presented?
7 lawmakers swear an affidavit
before the House of Assembly
that they had defected. Did they ever swear an affidavit to that?
That's the allegation that they said, that they sworn an affidavit.
So you are unaware?
They swore an affidavit?
You are unaware of any affidavit that was sworn?
If they have the copies...
Are you aware?
I heard it like any other person, that they swore an affidavit. But I've not cited the affidavit.
Interesting.
So as a lawyer, would like to see what I've not cited?
Okay, go ahead.
So, even if they swore the affidavit, the so-called affidavit, what is the implication? What effect would the affidavit have? That even the so-called affidavit that they said they swore, was it challenged? Was the affidavit challenged before the court? Was it challenged? Was it counter-contended? Was there evidence? I'm so flabbergasted. I'm almost carried away by the luxury of emotions that the governor is attracting, on the popular, on the street, kind of, there's this, there's a fun play, everybody seems to believe that they have done it. This is, but the question is that what the law is saying? This affidavit, they didn't counter contend, they didn't challenge until the matter was withdrawn. When issues have not been joined, you must take cognizance when issues have not been joined. So can you use that affidavit? When issues have not been joined. What they did, rather, was to go back after the said withdrawal. First, they started at the High Court of the State, Justice Wale, which was appealed to the extent where the Court of Appeal. And that's one of the matters that's also going to come up at the Supreme Court. Held that the lower court has no jurisdiction. You remember, it was like a Christmas song. They appealed it. The court said, we have no jurisdiction. Now, they are in the Court of Supreme Court. On a constitutional matter, section 173, sub 2 of the law. 172, 173, sub 2 of the Constitution. It's a constitutional matter. It is not matter mechanics and traders, market women discuss. That's what is happening under mango tree discussions. People choose now to, be carried away. No problem. But in this, let us look at the fulcrum of the issue. I am much particularly concerned with the law. I'm not here. I'm a justice crusader. I'm a human rights activist by my nature and by my practice. But when the law makes a stand on certain things, I am expected to defend, most especially when it is just. So the drama behind this whole thing is that what we watched on TV by the 27 House of Assembly members is a drama. I have never watched that kind of movie before. It's a new drama.
Was actually a televised defection.
Something that looks like, but in law, was
it a televised defection?
I don't even see that as a defection.
Do you recall?
Do you know what we mean by defection?
Do you recall the words that were said during that particular program?
You don't defect.
I understand what you mean, that televised defection does not translate to constitutional defection.
Legal defection.
Which is still constitutional. So now, before the law is going to look at what the Constitution says without emotion. So in your opinion, as long as there was no party registration and that defection did not follow the legal means.
Exactly. There was no formal presentation of cards to them as to signify that there was a defection. And then there was no transmission. They can quote me. They can challenge me. There was no transmission. There was no written transmission from individual. You don't defect in groups. So you don't defect. Defection is not in groups. All of us today, all of us from here. Oh, we are no longer don't know us as ATL, Atlantic View, ATV television correspondents. We are no longer. What shows that we are no longer? Where are we now? Where are we now? Is it just by saying we are not? Where are we now? So there was no registration. There was no exhibits showing that there was any written transaction between the member defecting. And you know that when you defect in your ward. Everybody defects in the House of Assembly. To who? You see, it's unfortunate that whatever happened. But it was a drama.
So for you, it's a drama.
It's a drama.
That cannot stand the test it cannot stand before the law.
It ought not to.
If it is tested according to the law, it will not hold. That's what you're saying.
It ought not to. That's my language.
Okay, it ought not to.
Yes, because the matter
decision does not lie in your hands. All right, interesting. But then, in answering, in delving into this, you didn't answer the earlier question that I had asked you, which is the issue of the pre and post defection. Now, I had told you earlier, or I have asked you earlier about concerns, you know, and these are the arguments that are rife, I mean, everywhere. The fact that Justice Omotosho's judgment, according to these arguments, they were pre-defection. And now, they are saying that the governor has a right to work with Okojombo because that judgment was pre-defection. And there is no judgment that has been given outrightly, you know, with regards to defection.
Let me
right. So because there is no judgment that has been given outrightly with regards to defection, the governor, you know, at his own discretion, will work with the House of Assembly that he considers legitimate.
See, let me tell you. I'm trying to. In section 192 of our law, Constitution, makes provision to the event that the judgment of any court, especially courts of superior records, can be enforced anywhere and to be binding on any and everybody, usually. When I told you on this show that sometimes the court usually will not waste its time by delving into trivial issues when it can indeed make an order to say, okay, see, these things was not done rightly. These things were not done rightly. You didn't do this thing rightly. In essence, it was wrong. The court has also told you that that thing that you thought you have done is not what it is. Justice Wale, the appeal against Justice Wale's, the court did, I told you here, the court didn't need to waste its time by going to say this one was no longer a member. Already, once there is no jurisdiction, court does not waste time to strike it out. It will strike it out. So the issue of God didn't mention Amewule. The question Nigerians should ask, when Amewule and the other people were suspended, did they challenge it? Up till today, as I speak to you, they have not deemed it fit to challenge their suspension.
When Amewule was suspended.
Sorry, when Edison and the other four were suspended, they did not challenge it even till today. Rather than challenging that suspension, and you remember that the suspension, as at then, there was no contention of who is the Speaker of the House. I hope you understand. Let us marry it this way so that you can understand.
I understand what you mean. As at the time Edison was suspended, there was no contention as to the speakership of the River State House of Assembly. So we had one speaker,
and the Court of Appeal said so.
Okay.
In that Wale's appeal, said so, if you remember. So there was no contention, and they were suspended, meaning that the suspension was legal. Now, rather than challenging the suspension, they decided to go their separate ways and constitute themselves into a group by calling themselves House of Assembly members, River State House of Assembly members, with which the governor went and presented the budget before them, before members that were suspended. And the suspension was that they cannot carry out any legislative duty. I hope you understand, within the period of that suspension. And it was still within the same period that the governor of Rivers State went to them and presented a budget to members who were suspended by a legitimate speaker, and that they did not challenge the suspension, and entertained a budget of Rivers State of 32 constituencies, invariably to them shutting out 27 constituencies, and they did not challenge that suspension and made themselves House of Assembly members. This is the budget that we are talking about. So, in view of this analysis, can you say that the budget has been overtaken by event legitimately? I don't know that you get you marry the legal term.
The argument of the budget being overtaken by time is that, I mean, this was 2024 budget. The budget in contention, you understand, is the 2024 budget, and that budget has expanded this lifespan. The money has been used. This is what they
unlawfully used.
Unlawfully used.
So because it was not appropriated for by the authentic assembly.
All right. So now they are saying that that money has been expended. The lifetime of that budget has come to an end. So that money cannot be brought back because it has been expended. And the budget itself has been overtaken by time because we are in 2025. And while we are contending
it's not a
that
moral
of
2024,
2025 budget was still presented to the same House of Assembly. But 2025 budget is not even in contention right now. It's still the 2024 budget. So they are saying it has been overtaken by time.
If the 2024 budget has not gained proper standing, is it the 2025 budget? Is it not the same error? So, in fact, see, I am just very surprised. I'm telling you, even if I see the governor, I will say it too. I'm very surprised that up till now, the governor has failed to read the handwriting on the wall. Courts are usually not happy when you don't obey their judgments. No courts will be happy. Courts are not independent. They are so connected. When you don't obey court judgment, the courts are not usually happy. If the court have said, see, present this to this set of persons, and you went further to do it again, it means it's an affront of the rule of law which you swore to obey. And I'm not just worried about the governor. I'm worried about those deceiving the governor. That's even the issue. People are worried about those deceiving the governor because he's not a lawyer, and obviously he will have to rely on the legal opinion of experts around him. So, I mean, it's an issue when we decide not to say the truth the way it's supposed to be. I quite agree, and if you ask me if I was in the know when this whole show was going on, obviously I would say no. It is not a better thing to even do because of the kind of impression it creates in the mind of the people, even if the law will not consider it so. But it, the tension and all the things it will create for that reason, it should be put to hold. If I was in know when all this, the alleged defection, television broadcasts and all that was, I would have said so. Because I have had opportunities with these people 2 to 3 or 4 or 5 times. So if I would have said so to them. I'm sure they would have also listened. But that, I won't say because this has happened. I'm more concerned about what the law is saying. It's not what, because I like Martin Samewuli. Martin Samewuli and me are not, we are not close friends. We are not close friends, but I will not ourselves, but we are not close friends. So it doesn't mean as if there's anything I have to benefit. I'm benefiting, but I am much more concerned. Nor is Okojumbo and the others, but I am much more concerned by what the law is. I told you, what Nigeria is running is what we call a pure law school theory. The theory that Nigerian courts are operating and the lawyers and all of us are operating on is what we call the Hans Kelsen pure law school theory. And what is the theory? It is only that which the court says is law. That which the court pronounces, that thing that the court says that this is wrong, this is right, is what the law is.
All right.
So what it goes to show is that Section 109 sub G is not self-executory. If it was self-executory, why are we going to court?
All right. Very